A high-profile legal challenge featuring 97 distinct claims has concluded with every single one dismissed by the court. This outcome, following an 11-week trial, signals a significant procedural and evidentiary hurdle for the claimants, specifically for Prince Harry. The judgment underlined critical issues regarding sworn testimony and the evidentiary standards applied in civil litigation. Prince Harry initiated 97 separate claims against the publishers of the Daily Mail and the Mail on Sunday. The trial spanned 11 weeks, involving 45 court days of testimony, cross-examination, and legal arguments. The presiding judge dismissed every single claim without exception. Reports indicated that Harry arrived in Britain for this period with 2 speeches prepared, one for a victory and one for a loss. The High Court judgment noted that Harry provided limited evidence on the core issues of the case and, while in the witness box, reportedly diverged from factual evidence. The verdict was delivered while Harry was at a public Invictus Games event at Chatham House, surrounded by veterans and with cameras actively recording. He received the news in person during these circumstances and consequently did not use the speech prepared for a win. The specific detail that fundamentally shaped the case's outcome warrants closer examination, as it often receives less attention than the overall number of dismissed claims. Under oath, Harry testified that his inner circle was highly guarded, with no close friendships with journalists or individuals positioned to leak private information. He stated, "My social circles were not leaky," and emphasized this point. This specific claim formed the foundation of the entire 97-claim case. The premise was that if his circle was truly leak-proof as described under oath, the only remaining explanation for consistent private stories reaching newspapers over the years would be unlawful information gathering, such as phone hacking or illegal private investigator activity, exactly the conduct he accused the Mail of throughout the trial. This judgment therefore extended beyond the simple civil defeat. It questioned the veracity of Harry's sworn testimony in court, raising serious questions of credibility. The Mail's legal team then introduced a series of years-old Facebook messages between Harry and Charlotte Griffiths, a royal writer for the Mail on Sunday. The tone of these messages significantly countered the image Harry had presented under oath. The exchanges were casual, familiar, and unmistakably friendly, indicative of communication between close acquaintances. One message read, "Hi, it's H," followed by a clarification. Griffiths replied, "Hello, Mr. Mischief." The exchange continued on a first-name basis across multiple messages and, at one point, specifically referenced missing their movie snuggles together. This phrase became one of the most widely quoted lines from the 11-week trial, cited by nearly every outlet covering the case. The Channel's perspective, reiterated previously, suggested that King Charles should consider revoking the titles of Meghan and Harry, allowing them to pursue their own path to mitigate ongoing public drama and scrutiny. According to arguments presented in court, Griffiths had kept these messages private for over a decade before they surfaced during the proceedings, introduced specifically after her credibility had been challenged. Such a contradiction carries genuine and lasting weight within any courtroom, regardless of how minor it might appear outside the specific context of a sworn legal proceeding. A witness who states under oath that no such relationships existed and is then confronted with direct documentary evidence proving at least one did, invites much closer scrutiny of all other testimony. This is not due to the messages themselves being scandalous, but because the contradiction itself becomes a central point of the story. Separately, the Channel host has previously characterized Meghan as a source of evil and bad, noting that this view has not been universally popular. Reports from inside the courtroom describe the presiding judge intervening multiple times during Harry's testimony, specifically to redirect him toward answering the questions posed, rather than expanding into broader statements. Exchanges between Harry and the Mail's legal team also reportedly grew noticeably more adversarial and tense as the testimony progressed over several days. Before examining the broader reactions, the human element within this case merits closer consideration. Royal journalist Katie Nicholl, who's covered the royal family for approximately 20 years across multiple reigns and generations, had 17 of her articles scrutinized during these proceedings. Her sources and specific reporting methods were challenged directly in open court in front of lawyers and a judge. At the same time, she was recovering from major cancer surgery. She reportedly stated she could barely manage a flight of stairs, yet had to review old notebooks to defend reporting completed years prior. This combination of circumstances, recovering physically from major surgery while simultaneously having a 2-decade professional credibility, publicly challenged in court, occurred concurrently in her life. When the ruling was delivered, the judge not only dismissed the claims related to Nicole's specific reporting, but went further. He explicitly described her as a credible and impressive witness and formally accepted her evidence as honest and reliable. For any working journalist, such a finding, delivered by a judge on the record in a major case, carries significant professional weight beyond this single trial. Speaking publicly afterward, Nicole, visibly emotional, reflected on 20 years in journalism. She described the less glamorous reality of persistently seeking information, slowly and patiently building trust, and earning reliable sources through years of consistent, relationship-based work, rather than through unlawful methods. She specifically mentioned one source, a woman in her 70s genuinely close to the late Queen, who agreed to speak only after years of relationship building because Nicole had earned that trust. She stated, "I did journalism the hard way. I never witnessed anything in terms of what we were accused of doing. If this analysis clarifies details overlooked in broader coverage, supporting the channel helps sustain this in-depth approach." We continue now to an important aspect of this case that did in fact favour Harry. Estimates suggest the case could cost as much as £60 million once legal fees and trial expenses are fully calculated under UK rules. Harry could also be ordered to pay a significant portion of Associated Newspapers' costs, potentially adding millions more, possibly reaching a total of £100 million. Not every aspect of the trial reflected negatively on Harry. This side of the case warrants specific consideration before addressing the more damaging material. The court heard allegations that a private investigator working for the Mail obtained the specific airline seat number of Chelsea Davy, Harry's former girlfriend, and discussed the possibility of placing someone in the seat directly beside her during an international flight. If accurate, this constitutes disturbing conduct by any reasonable standard. Harry's legal team forcefully argued that it approached what many would recognize as stalking behavior. The court also heard direct testimony from Elton John and his husband David Furnish, who stated under oath their belief that their newborn son's private birth certificate and confidential medical records had been improperly and unlawfully accessed. There was additional testimony regarding how Harry first learned he had been named godfather to his former nanny's child. He argued this appointment could only have reached the public, and him through an improper source, given that this information was not publicly known or available at that specific time. These are serious allegations, regardless of an individual observer's view on the broader case outcome, and they deserve to be taken seriously on their own merits, rather than being dismissed as part of an overall loss simply because the larger case did not succeed. Focusing now on developments in the UK, Prince Harry's recent arrival generated considerable public attention. This visit once again ignited a robust discussion regarding his public standing. However, the legal distinction that ultimately determined the outcome of this case is critical to understanding why allegations of this nature still led to such a comprehensive dismissal. Alleging a privacy violation, however serious or genuinely felt, is fundamentally different from proving one under the specific legal standard applicable in a civil case of this kind. Because this was a civil case, the standard was not beyond reasonable doubt, but rather the balance of probabilities, meaning what was more likely than not. Even applying this comparatively lower legal bar, the judge repeatedly and consistently sought specific concrete evidence, demonstrating that any particular piece of information could only have originated from unlawful means, rather than from the numerous ordinary channels through which royal information typically circulates. Repeatedly, the court heard alternative explanations from male witnesses, and in a significant number of instances, the judge found these alternative explanations more persuasive than the allegations. Many of the individual claims in this case dated back 20 or even 30 years, meaning they relied heavily and often almost entirely on inference and reasonable assumption, rather than on direct documentary evidence that could be independently examined and verified. The ruling was explicit and unambiguous on this point. Inference alone, however serious the underlying concern, is generally not legally sufficient to decide a civil case of this scale and consequence. Paul Dacre, the Mail's editor-in-chief and a frequent target of Harry's public criticism, responded to the verdict with characteristic directness. He criticized Harry's memoir directly, arguing it exposed private family matters while Harry simultaneously complained about his own privacy being violated. Dacre remarked that the quantity of dirty linen Harry has aired about his own family would overwhelm any laundry, and stated Harry's privacy arguments take not just the biscuit, but the whole tin. He further claimed that Princess Diana herself, during some of the most challenging periods of her life, personally read and trusted the Mail as a publication. Supporters of the newspaper's defense argue that this claim makes the broader assertion that this specific paper operated unlawfully against the family for decades considerably harder to accept at face value. There is also a detail regarding the pre-trial period that warrants attention. Reports indicate that before the case formally began, Harry's legal team quietly explored the possibility of a financial settlement around Christmas, well over 6 months before the eventual judgment. According to those same reports, the Mail specifically declined that settlement opportunity, choosing instead to fully defend the case in open court. After the verdict, which overwhelmingly favored the Mail, many commentators pointed to this decision as reflecting genuine institutional confidence in their legal position, coupled with a willingness to have all underlying evidence publicly and rigorously tested. Despite the substantial financial cost for both sides, the actual costs involved were considerable, on a scale that many following the case found difficult to fully comprehend until specific figures began circulating. Under the loser pays principle broadly applied in UK civil litigation, the unsuccessful party can be legally required to contribute meaningfully to the winning side's legal costs, in addition to covering their own. Before the trial officially commenced, the court was informed that combined legal costs for both sides could realistically approach £40 million in total. By the time the full proceedings concluded, after 11 weeks and 45 court days, some reported estimates placed that combined figure closer to £50 million. While insurance arrangements may cover a portion of this total, and separate policies may cover additional amounts, depending on the final cost order issued by the court and specific policy terms, a genuinely substantial financial balance could remain outstanding. A further formal hearing is scheduled for the end of July, specifically to determine how these substantial costs will ultimately be allocated among the various parties. All of this transpired during what many commentators have independently described as one of the most challenging periods of Harry's public life since he formally stepped back from royal duties. Reports indicate Buckingham Palace initially offered him accommodation during this specific UK visit. An offer later formally withdrawn after a decision on acceptance was reportedly not made within the required time frame. Meghan and the children remained in the United States throughout the duration of this visit, adding another layer to an already difficult and heavily scrutinized week. Separately, and in parallel to the court case, reports circulated that the Invictus Games Foundation, the cause most closely tied to his public identity, was facing significant financial pressures and fundraising difficulties leading into the upcoming games. To many observers, this cumulative series of events, including a reported £50 million legal defeat becoming the week's dominant headline, indicated another missed opportunity for reconnection with the palace, while his family remained an ocean apart. The legal costs are not yet fully and finally determined, pending the further hearings scheduled for the end of July. The other individual claimants involved are still processing the implications of this verdict for their personal positions and next steps. The broader question of how all this ultimately affects Harry's public standing in the coming months remains an open one. Does the Charlotte Griffiths message contradiction genuinely alter your perception of Harry's sworn testimony throughout this 11-week trial? Or was this outcome always realistically determined by the applicable legal standard, irrespective of specific evidence like the Facebook messages? Your perspective is welcome in the comments.